from the Beyond Unreasonable Doubt Studios, in association with Feitner Productions, it's Lay Down the Law! With your host, Billy DeClercq.
Hey, that's me.
Yeah, that's right, Billy, that's you. Featuring Blake Oliver, Lauren Michaels, and Curtis Retherford. Only a madman would dare to bring these people together to build a world of law and order, only to tear it apart with laughter. That madman is attorney Billy DeClercq. The result is a podcast blasted to the farthest reaches of the internet. That podcast is this one, and it starts right now.
Welcome to Laying Down the Law Earmark Edition, the law and comedy podcast hosted by me, the unacknowledged bastard child of Steve Martin and Ruth Bader Ginsburg. You know, it's a really hot summer in the Hamptons. I'd like to introduce my three returning guests. First, he's a returning guest from season 1, a CPA who specializes in cloud technology and the co-host of the Cloud Accounting Podcast, a weekly news update for accountants and bookkeepers. He's a 2-time honoree to the CPA Practice Advisors 40 Under 40 list, and he's been named to Accounting Today's top 100 most influential people list. At Northwestern University, he majored in cello performance, and his musical ear is why he's the visionary behind Earmark. See what I did? My main money man, Blake Oliver.
Billy, it is awesome to be here with you.
It's awesome to have you back. And we're going to have some fun today. Going to make you break out of your comfort zone.
I hope so.
All right. My next guest is a writer, improviser, and host of the podcast Improv, Beat by Beat. His writing may be found on McSweeney's and elsewhere, including Twitter, like a lot. He's also a member of Megaplex, the improvised movie, Fluffy and Ghost, the improv group whose 75-minute improv set recorded in the first year of the pandemic took me the entire second year of the pandemic to, quote, fix in post, end quote. He's the one and only at actually Curtis Retherford, Retherford. Welcome, Curtis Retherford.
Thanks, Billy. Good
Thanks
to be back. Can't wait to do a 3-hour improv set this time.
Yeah. It's a Marvel movie length improv set.
Mm-hmm.
All right. And welcome back. Another returning guest. She is an actor and comedian who enjoys writing while riding a bicycle. Even though she's from Dayton, Ohio, and she's cringing as I read her bio, she studied theater at the Stella Adler Studio and mastered making mistakes in New York so that she could share her gifts as a standardized patient in Pittsburgh, influencing and impacting future doctors of the world. And you're welcome, doctors and patients. She enjoys camping and driving across the country, which led her to discover La La Land as her most natural habitat. She performs stand-up comedy weekly while procrastinating on other pursuits. Follow her down the rabbit hole or on social media at LOrangeMIC, LOrangeMIC, and at Sweet Relish Films. Welcome back to the podcast, Lauren Michaels.
Thank you. Thank you for reading that. And it is the Stellar Adler. That's how
It's a Stellar Adler. Oh, now we're gonna have
that's the British pronunciation.
Yeah, we're gonna have to.
It has to add an R in there.
Yeah, Stellar Adler. Well, I'm thrilled to have. Yeah, I'm thrilled to have you all back on the show. But first, a word from our sponsor.
Insert advertisement here.
Okay, Blake. Thanks for getting us that sponsor. I really appreciate it.
Yeah, I hope
No pressure.
I hope I do. Yes. Thank you.
I hope I do. Thank you to 1-800 deliverything.com.
When I needed a delivery thing, I called 1-800 thing.
They deliver all the things.
But
there is a 1-800 accountant. There is a 1-800 accountant.
1-800 accountant.
Yes. They're probably not the sponsor.
No, there's emergency accounting needs.
Yes.
All right. All right. Well, this week's case is Gorton versus Doty. It's a 1937 case from Ohio.
Wait. Billy, aren't you going to this is the first episode, right? We're going to lay out what this is?
Oh, well, we have so many returning listeners. I'm sure they all already know. But since we're the first episode on Earmark, for all you new accountant listeners, what do we do on Laying Down the Law? Laying Down the Law is a law and comedy podcast. We take law and then we run it through the meat grinder of comedy in order to make it understandable and fun. I call it edutainment. Now, adding accountants, I used to say it's like the peanut butter and chocolate, that two great tastes that go great together. But now that we're adding accountants, it's like a PB&J sandwich. It's bread would be the law bread. The peanut butter would be the improv peanut butter, and accountants, you're the jelly, the delicious, sweet fruit part that makes a PB&J a PB&J instead of just a PB.
Arguably the best part too.
Oh, fantastic. And because this is for accountants' continuing education credits, we're going to go longer than the usual 20 minutes. So you can get a full 45-minute accounting continuing education credits. Now, how does this work? For those of the many listeners who are following Laying Down the Law from our traditional audience into this new space, for our many non-accountant listeners, how does this work?
So we have to hit a total audio duration of 36.2 minutes per National Association of State Boards of Accountancy rules.
36.2, easy.
Yeah.
Oh, yes.
Don't miss the point two. It's very important. So if we do that, we can offer an hour of CPE credit for this episode.
This is what I love about accountants. How long is an hour? 36.2 minutes.
Well, the multiple choice, the 8 multiple choice questions are themselves worth a certain amount of time. So
Fantastic.
But it's really a 50-minute hour.
Yeah,
just
absolutely.
to clear things up. Yeah.
I get it. It's a 50-minute hour, of which 36.2 minutes is the actual time, and other questions are the time within the 50-minute hour that aren't included in the 36.2.
Oh my God, Curtis, you should be an accountant.
Thank you.
You got that faster than half of our audience. Yes.
Oh, absolutely. Yeah, I was going to ask. I think I added you on Twitter, and this is by the way, accountants. This podcast does venture into explicit language, so I'm just going to warn you. So if I couldn't give 2 shits about something, then that means I could give 1 shit. But the question then is, what happens to the second shit? Also, if I'm giving a shit, does that mean that the 1 shit is a deduction? And then is the second, what's the tax treatment of the second shit, which I do not give?
I'm not a tax accountant, so I don't have to answer that question.
Perfect. Well, write me at Max Headroom Esquire with any answers, and make sure you hashtag I don't give a shit at all when you send it.
I mean, if it's a donation, that's a write-off, right? I think I know that much.
Well, it's a gift. I guess it's a gift. Well, it depends on whether it's a gift that's a charitable gift or a gift that's an inheritance gift. Generation skipping shit.
My grandfather died and he gave me 1 shit.
Yeah, exactly.
Can I write that off?
Yeah. No, he can write it off.
He can write it off.
He can write off the shit.
Oh.
I don't give 2 shits about my grandkids. I don't give 2 shits about my grandkid, but I do give 1 shit. Anyway.
Why were we talking about the shits?
Well, because this is a tax accounting podcast. And so that's all I know about tax and accounting is that what can I write it off? Essentially, the thing I understand about accounting is that you write off everything and then you tell your accountant, can I write off everything? And they're saying, and then they say, are these audited financial statements? And then I say no. And then they say, do whatever you want.
Welcome back to the Wesley Snipes Accounting Podcast, where you will find out everything you need to know to go to jail.
Yeah.
I have to change accountants. My dad's my accountant now, and he's so prideful about his business. So he doesn't do any write-offs. It's horrible.
Oh, yeah. No, in all seriousness, the reason I'm doing this, because I don't know anything about accounting, if you haven't gathered that in the first 4 minutes, I am a lawyer. So I understand that accountants need to keep up on business law, right?
Yes.
So this is meeting the business law portion of the accounting. And this case that I'm doing, Gorton versus Doty, is actually from my business law book. I'm going to go get it off the shelf. Hold on one second.
And while Billy does that, I think in full disclosure, everyone should know that Billy was once my bookkeeping client long ago. So, yeah. And that's how we know each other.
Okay.
All right. Since this is an auditory medium, excuse me, I just walked across my office and I got Business Associations. Clearly, it's a well-read book that I read many times, and I flagged all the pages I read. There are 2 Post-it notes in here. And I'll go ahead and open to page 1, chapter 1, on agency law. Agency, for those of you who don't already know, is the power of one person to do something on behalf of another person. So the principal is the person for whom something is being done, and the agent is the doer of things on behalf of the principal. And the reason this matters is because
he's putting on the glasses.
I am, because I'm going to actually read from this book. The reason this matters is because if an agent signs a contract, then the principal is bound. If the agent commits a tort within the scope of agency, then the principal is going to have to pay for it. So, for example, employers and employees, if the employee, serves somebody very hot coffee, and then somebody who gets served the very hot coffee spills it, the employee who serves the very hot coffee can be sued, but also the maker of said hot coffee can also be sued. So that's why principal and agency relationships matter. So this case is a case involving an auto accident. In September of 1935, this lawsuit was brought by one R.S. Gorton, who sued because his son Richard, who was a high school football player, he was a junior at the Soda Springs High School, was injured in a car accident being driven back from an away game in Paris. I assume that's Paris, Idaho. Occurred on September 21, 1935. He was being driven by an adult volunteer in a privately owned vehicle. So this was the old carpool. The car that Richard Gorton was riding in was owned by Charlotte Doty. She was a teacher at Soda Springs High School. And the car was being driven by Russell Garst, who was the football team's coach. This part isn't in the highly edited version that's in the law school textbook, but Russell Garst was 22 years old.
The driver
of the car. So the reason this comes up on an agency law analysis is that at trial, there was $870 in monetary damages that were owed to the father for medical bills and so forth. And Richard Gorton was awarded $5,000. In the trial, Charlotte Doty was found liable for $5,870 because it was claimed that Coach Garst was her agent. And so one of the issues that was appealed, there are a lot of issues appealed, but one of them is, was there a principal-agent relationship between Charlotte Doty and Russell Garst that would cause Charlotte Doty to be fully liable for the things that Garst did?
So basically, because Garst is driving Doty's car, Doty, according to this, is fully on the line. It is as if Doty were driving the car herself.
Right.
And hit young Richard Gorton.
Well, Gorton was a passenger.
Gorton was a passenger. So she really didn't hit him. So Gorton was in the car. It was as if Doty was drunk, drove off, injured Richard, but even though she wasn't there, she just lent her car. It's equivalent legally.
Right. And that's exactly the situation. So her defense was, I just loaned my car to the coach. And the law is that if you just loan your car, it's called a gratuitous bailee. A gratuitous bailee means you loan something to someone. Bailee. A bailor is the person who does the loaning. The bailee is the person who gets the vehicle. And gratuitous means for no money. It's a gift. So if she just loaned the car, to Garst, then she wouldn't be liable. But if he was her agent, he would be liable. And so she testified at trial that she had just loaned the car to Garst. He wasn't her employee. He didn't work for her. He didn't promise to pay her anything for the car. And basically, she testified that the day before the game, they were apparently maybe in the teacher's lounge or something. She had asked Garst if he needed another car to drive the kids to the football game. And he said yes. And she said, you can use my car.
So wait, why is she getting sued? I don't know. Why is she a defense?
It was her. So it was her car.
Right. Well, like, what happened?
Oh.
Why did?
Well, this is one of the interesting things. I was preparing for this podcast and I actually read the entire case, which is not something I usually do. And so you get these highly condensed cases, and this is a swipe at lawyers, but they can take it. So you get a highly condensed case, which is intended to make a legal point. And obviously the cases that are put in are weird. They're on the line. So this is a case that illustrates this point and potentially was wrongly decided. So what happened in the accident isn't in the law textbook, but I found out researching. So I'll tell you what happened in the actual case since you asked. Or do you want to know what the legal point is first?
No, I would love to. I'd love to just figure out what happened in what led us to this point.
So let me tell you first the facts that matter to the question presented. The question being whether Russell Garst was the agent for Charlotte Doty is this. She knew the Soda Springs High School football team was going to be playing the Paris High School football team at Paris High on September 21. She volunteered to use her car, transporting some of the members of the Soda Springs team to and from the game. She asked the coach, Russell Garst, if he had all the cars he needed. He said he needed one more, and she said he could use her car if he drove it.
Did she go to the game?
She did not.
Okay.
Yeah, she did not.
They all pile into the cars and they go to the game.
Pile in the car, yes. She wasn't promised any compensation. The school district paid for the gas. She loaned the car, and she'd not employed him. She not directed him to do his work or services or what he was doing. Okay.
Loaned her car.
That's it. Except she said nobody else was to drive it.
Fair enough.
Okay.
Does that only you can? Is that what they're saying? Because she said only you, Garst, can do this. That is equivalent of saying you are my agent. You are being Doty right now. You are being, what was her first name?
Charlotte.
You are being Charlotte Doty and driving my car.
She said in relating the conversation, that was the extent of it. Question. On or about the 21st day of September, 1934, state whether or not you permitted Russell Garst's car to use the car. Answer. I did. Under what circumstances? I loaned it to him. When did you loan it to him? Was it that day or the day before? On the day before, I told him he might have it on the next day. Did you receive any compensation, or were you promised any compensation for its use? No, sir. What were the circumstances under which you permitted him to take it? Well, after having so testified, the appellant was then asked, you may relate the conversation with him if there was such conversation. Answer. I asked him if he had all the cars necessary for his trip to Paris the next day. He said he needed one more. I said that he might use mine if he drove it. That was the extent of it. And the court says, we therefore conclude the evidence supports the finding of the jury that the relationship of principal and agent existed between appellant and Russell Garst.
Okay, so they all go to the football game. Everything's fine getting there. It's on the ride back, the drive back. That's when there's a crash.
All right. Well, you want to know what's not in the case book. You just keep pushing, Blake. You keep pushing and you keep pushing. I'm just going to tell you, this whole part is not relevant to the decision of the case. It's not in the Business Association's case book. It doesn't tell us anything about principal and agency law, and yet you still want to know.
Okay, did they win the game? This is what I need to know. Did they win the game?
That's not in the case at all. I don't know about that. But
if they were celebrating, maybe there was Gatorade thrown, something.
I don't think there was any Gatorade in 1935. I think it was whiskey.
Really? I thought Gatorade was old as Mountain Dew. I don't know.
As old as, that old saying, as old as Mountain Dew.
I think, the Mountain Dew came over on the Mayflower, I believe, was it? It was a.
Sorry,
Yeah.
The Pilgrims drank it.
I didn't read your briefing, Billy.
Yeah.
So I'm trying to get the facts straight here. So
Yeah.
they got into a crash.
Oh, you want to know about the car? He wants to know about the crash. All right. So
there was an accident, right?
Yes. So here's what happened. Richard Gorton, at the time of the accident, had been driving for about 3 or 4 years. He had experience as a passenger in a car. That's Richard, the son who was injured. He estimated that the coach was driving about 55 miles an hour when the accident occurred. But he also testified he wasn't really paying attention where the car was being driven or how fast it was going. He was seated in the front seat between the coach and another member of the football team. So they had 3 across the front seat, and there were 2 members in the back seat. On the highway where the accident occurred, and for several miles in either direction, was smooth and oil surface. The highway was dry and there was no other traffic at the point in time of the accident. The accident happened at a sharp 10% curve just after dark, that the car lights were on, and Richard Gorton did not object to the speed it was being driven. He testified that the coach didn't ask the boys to go with him. He just told them, "You're going with me." Kind of like out of order, but anyway, when the car reached the curve, it moved straight ahead from the hard surface onto the shoulder, and from the shoulder into a borrow pit and along a bank at the side of the road until it reached the end of the bank, where it left the highway and continued down a steep slope and into a gulch some distance from the highway. The automobile was practically new and in good condition, and that the coach died shortly after the accident from the injuries received.
Jeez.
So that's why he was not being sued. Okay.
Now I get it.
And what kind of car is this?
It's a fairly new car. It doesn't say what the model is.
It was an old timey car. This is
A
1935.
Model T or something?
Yeah. It was an Edsel.
An Edsel. So, okay, wow. So they're in a bad accident just caused by like probably, somebody like the coach kind of drifted off maybe, or wasn't paying attention, missed the bend, right?
Right.
Drives off the
Well, it
road.
was like
He drove off the side of the road, basically.
Okay.
He's going about 55. There was a big curve, and he rolled right off the side of the road down a ravine.
So
And-
Richard Gordon's dad decides to
Monopoly
sue
cars.
the owner of the car, Charlotte Doty.
Right. And
Okay.
when I get to the dissenting opinion, I'm gonna get into what I think is really going on here. But the expenses were sued for hospitalization, doctors, surgeon, nurses' fees, and then the father also, as a guardian for his son, brings it to damages for injuries that he sustained. And there's testimony that basically his leg was fractured and he didn't walk the same afterward.
Poor kid.
Yeah. So there's a whole discussion in the full case that doesn't have anything to do with principal and agency about whether the damages were excessive, because $5,000 is a lot of money in 1937. And basically they said it was because he had this permanent injury.
Yeah, that's like almost $100,000 today.
Yeah. It was, it's not, it's not the Barnes firm kind of money, but it'll get you there.
Quick question about like principal and agency before we go more into like the how it's being possibly misused here.
Uh-huh.
So what are the normal like aspects in which somebody is definitely working as an agent for me? Like normally what I have to say, Billy, you're my agent, you are selling my boat, you are doing this, or Billy, you work for me, and because you work for me, you are now automatically my agent.
Yeah, I'll give you an example.
Okay.
At one point in my business, I had an office where I received mail that was separate from where I was actually running the business. And I had a couple of employees. And so one of my employees, her job was to drive over to the office where we got the mail every day and pick up the mail and bring it back. And I was sharing the office space with someone who worked for an insurance company. And he said, you should really get insurance for your employees' use of a vehicle, because if your employee gets in an accident while driving over to the other office to pick up the mail, you could be liable, because that is driving within the scope of employment. So she was my employee. Her job was to drive over, pick up the mail, and drive back. Now, why was I so worried about my privacy that I couldn't use my actual address is a whole other story.
But because she was your employee, she's just automatically
She's on the
working
clock
as an agent for you.
Right. So if she had gotten in an accident driving those 2 miles across town, whatever would have happened, I could have been sued. And so I had insurance to cover that expense, that risk. So that's the clearest example of principal agent relationship is an employer employee relationship. An attorney is an agent for a person. Obviously a real estate agent is an agent for a person. Usually it's established by some kind of a contractual relationship. A CPA can be there he goes, making it relevant. A CPA it can be an agent. And in some cases, an accountant could sign a contract for a company, potentially
bind the
company if they're held out to be an agent. There are a lot of other aspects of agency, whether it's implied or actual agency, or whether there's contractual agency, or whether you give the impression of being somebody's agent. So, partners are agents. So if you enter into a partnership with someone, unless you have a specific written agreement and it's a general partnership, then the act of the one partner binds the other partner. So when you're partners, you're both principals and agents of one another. So anything one partner does, this is sort of a side note. I give a lot of people advice, and one of the things I'll remind them is personal, unlimited liability for the acts of your partner within the scope of the partnership. So that means if your partner goes out and takes out $1 million loan and you didn't know about it, and it's a general partnership, meaning you don't have an agreement, you're on the hook as a partner because you're a general partner. So unlimited liability for the acts of your partner within the scope of the partnership. So those are principal and agency relations.
Gotcha. And so that's like the normal vanilla version. And then this obviously is like the borderline case where he, Garst did not work for Doty.
Right.
He worked for the school. It's weird that the school isn't at all part of this, right?
That isn't interesting. I think these days you'd almost certainly have sued the school.
Or the car company for making an unsafe car.
Mm-hmm. And also the highway, also the, the Department. Boy, we are like plaintiff's lawyers right in here. Yeah, you would have sued the Department of Transportation for not having a guardrail, for not marking it, not having a sign.
Also the car went through, I think they said a burrow and then a ditch. And then another thing, I'd be suing the ditch, the gulch, the burrow, exactly. All of those.
The animals that live in the burrow.
Right. Exactly. Yeah. Yeah, he went off the road into a ditch and then down a ravine. Not good. No airbags at all in 1937.
So that's principal and agency.
Mm-hmm. Okay, so here's a nice quote from Richard at trial. He said, "Well, the first thing I noticed, sir, was the side of the bank coming up and going off the road. And then I noticed him trying to pull the car back on the road from the shoulder and the gravel and then skidding into the bank. Golly gee, sir. I can't walk no more."
So because of this riveting testimony and his Tiny Tim-like inability to walk, his pulling on the heartstrings of the court, they say, okay, Garst was definitely the agent of Doty. Therefore, Doty, you're on the line. You owe all of this money.
Right. And the test, the real test of agency here is the idea of control. So consent and control. So agency is a manifestation of consent that one person will act on another person's behalf and subject to their control. And then the consent by the agent to act as an agent. So the court here, the majority rules that Doty and Coach both consented that he would drive her car. It doesn't matter that he did it for free. You don't have to pay someone to be your agent. Essentially, because she said, you're the only one that can drive it. They thought that was really important, that the jury could find that he was her agent.
This seems kind of crazy that just loaning somebody your car and attaching a condition to it can establish agency.
Right. That's how it gets in a law school textbook for sure.
Is that still the case?
I'm pretty sure you could argue this is a wrongly decided case.
No way, because then Uber would have to pay a lot more for a lot more things going on.
Well, and I think the thing about, Uber is a great example of agency law because, and there's, we could do 3 or 4 episodes of a podcast about Uber's handling of agency law because obviously they have contracts, multiple layers of contracts, click wrap contracts. They've been sued and accused of being an employer of these drivers. Then they went and changed the law, and got a ballot initiative passed. It's kind of a whole layer upon layer upon layer. So it
now
seems
technically Uber drivers are just friends of Uber.
Yeah, exactly.
Right.
And I've noticed actually that Ubers have gotten really hard to ever since the pandemic. It's like it's been very difficult to even find an Uber driver. It's like your Uber driver will be here in 27 minutes and then they cancel halfway through. And Uber is not a sponsor of this podcast. Wah, wah. No. So sad. Judge Budge spoke up and dissented. Judge Budge's dissent focuses on how weak the connection is and how little control Charlotte Doty had over Coach Garst.
Real quick, Judge Budge is such like a Disney name for a judge. Like that's the judge that tells Mickey that he has to pay those 2 pies back to Goofy.
I couldn't resist mentioning it. Judge Budge.
That's the order. Yeah.
And that'll be the order of the car. Yeah, exactly.
Get me a milkshake.
Exactly. Now he's one of the Ronald McDonald gang.
There's a crossover there.
Exactly. So there's no evidence to support that the coach was the agent at all. He says, an agent is someone with a business kind of relationship or to manage their personal affairs with their authority. It's not enough to just give permission. There wasn't really any instruction as to what they were going to do. They worked at the same school and the coach was loaned the car on his own. She just loaned him the car out of the kindness of her heart.
So isn't this his agency? It's his team going.
Right. I mean, he was the one acting.
It's not even like he's doing her job. He's
right.
doing his job.
Yeah. The only reason that the majority says is that he said, well, you have to drive it because he says that's obvious. He didn't want any of the teenagers to be driving it. So she loaned the car. This is your exact point. Judge Budge agrees with you. She loaned the car to the coach for his benefit, not for her own. She just wanted him to avoid an accident, which, was not, that didn't turn out, but it didn't make him.
I asked you to do one thing.
One thing. Don't crash the car.
Stay out of the gulches, the ravines, the burrows.
All of it. And then Judge Budge points out, and this is a quote, one who borrows a car for his own use is a gratuitous bailee and not an agent of the owner. So there's something else going on in this case. And this isn't part of the business law part of it, but Judge Budge points out that there's this statement in closing argument by the plaintiff's lawyer. And he says, you have a right to draw on your experience as businessmen. 1937, all male jury. Sorry. You have a right to draw on your experience in determining the facts in this case and what you know from your experience as businessmen. Sorry, 1937. That prudent automobile owners usually protect themselves against just such contingencies as are involved in this case.
So sorry, that was the
plaintiff's attorney.
Okay, so basically saying this is what she should have done. If she were smart, she would have defended herself as a prudent automobile owner.
He's hinting to the existence of insurance.
Gotcha.
So he's saying prudent automobile owners usually protect themselves against just such contingencies that are involved in this. So he's hinting that she had insurance. And so the law is that you're not allowed to say that the defendant has insurance. It is error. It's grounds for a mistrial. And so when this happened, the defense counsel called for a sidebar and they went into chambers, and basically defense counsel asked for a mistrial on that basis because they improperly referred to her insurance. The court didn't think that was grounds for a mistrial. And so the judge went back into court and he repeated the testimony and then told the jury to disregard it.
Okay. So this is making sense to me now because I'm thinking to myself, why would a jury go after this school teacher for $5,000, the equivalent of $100,000 today, when her car was destroyed through no real fault of her own. She just loaned the car to the coach. The coach is also dead. It's a terrible situation. But clearly, the kid has medical bills, and somebody's got to pay for it. And the jury gets the implication that there's insurance that's going to cover this if they make this decision, right? Like that's what's got to be what went on here.
I think that's probably right.
And that happens a lot, right? Like, I mean, that's got to happen today, right, Billy?
I think it happens all the time. I think juries sort of guesstimate about what's the rough justice and don't necessarily pay attention to the law. That's the role of the judge, is to make the legal rulings, and the jury is to interpret the facts. And sometimes the jury just tries to do what they think is right, not really necessarily following the law. And so the argument of the defense, he uses the word mulct. You're trying to mulct the defendant in damages.
Wait, what word is that?
Mulct, like mulch, mulct. He's trying to mulct the defendant in damages.
Feels like 1930s Ohio slang that has not survived.
It didn't make it. So the judge denied the motion for a mistrial and instructed the reporter to read the remarks to the jury again, and then instructed the jury to disregard the remarks. So in case you missed it, you have a right to draw on your experience of businessmen in determining the facts in this case. And you know from your experience as businessmen that prudent automobile owners usually protect themselves against just such contingencies as are involved in this case. Pay no attention to that statement whatsoever. You're to disregard it.
And so I take it Judge Budge, who did not budge in his opinion to go with the majority, that was on appeal. That was some sort of like...
He was the dissent. So I think there were, let me just check. I think there were 3 in the majority, and Judge Budge was the dissenting judge. Or two, maybe I think it was a 3-judge panel, 2 and 1, something like that. He was in the minority opinion.
Got it.
Mulct means to punish.
I look. Google tells me it says extract money from someone by fine or taxation.
Mm-hmm.
Oh, punish,
Yeah. The inference was that the respondent was attempting to punish her for having volunteered the use of her car. And so he basically argued, this is the plaintiff's lawyer. He said, that's not punishment. I'm not trying to mulct her in damages. I'm just saying, she probably has insurance.
Are you trying to mulct me right now?
I don't let a day go by when I don't mulct people.
This is a good word.
The mom's been mulcting people for
Absolutely.
That's how they do it, right?
Absolutely. So that's the case, folks. Gorton versus Doty. 1937 Ohio.
So this is case law today. I guess what's the lesson here? Is it just that you really, 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 really want to avoid agency relationships? I mean,
I don't think there's a moral to this story, unfortunately. I mean, we just really skip over morality in law school. There isn't really a lot of that until the 3rd year. Usually first-year law students come back and it's like, I read this interesting case about a murder. Oh my God, what's wrong with you? It just takes the morality right out of you. I think so the point here is to understand how agency works and, what are the circumstances that create agency, and to make a vivid point here that it involves a certain amount of control. And I think the idea being this is the first case in the law book, so that the law students all have the same reaction when you get down to it. Like, this is not right. This seems wrong. It shouldn't have been an agency. It's pretty clear. I'd say it's pretty clear this is a wrongly decided case. And I apologize to Judge. I don't know who wrote I remember
the trial judge.
The appellate judge, Judge
Holden. Fudge, Judge Mudge. Oh, Hold'em. Okay.
Judge Hold'em.
Really? We have Judge Hold'em and Judge Budge on the same appellate court?
Yeah.
And Judge Ante.
Not Holden, like Catcher in the Rye.
No, it's like Catcher. It is like Catcher in the Rye.
Oh,
but
Hold'em
it is. Okay.
Hold'em would be funnier. You can blame the trial court judge and Judge Holden for, probably the judges are thinking the same thing. We got to give this kid some money. It goes into a whole thing about his fracture, and then they try to heal it using 1936 medical technology. It was a simple fracture, not a compound fracture, and they put it in a cast, but it didn't quite heal right. So, little Richard Gorton kind of limping around Soda Springs High School. It's his senior year, for God's sake.
Maybe he was the one that threw the Gatorade, you know?
Mhm.
What goes around.
I thought we had established that there was no Gatorade in 1935.
Hold on.
I
Since
wanna
we're looking
believe that
everything
there
else
was.
up, we're gonna find
Yeah.
out
Yeah,
when
let's
Gatorade
fact
was
check that.
invented.
Yeah.
I think it was like 1960 something. Let's see.
Yeah, 65.
Yes.
University of Florida
Five.
College of Medicine.
Mhm.
There it is.
Well,
They
that's
had a lot
30
of
years
extra
off.
salt.
I did know that part about Gatorade, that it was in Florida.
Yeah.
Right.
It gave them
Okay, so-
such a huge advantage.
Because the Gators.
So my takeaway from this is it is exceedingly easy to create agency without intending to do so.
Yes, that's a really good takeaway, and that's actually a valuable. Like, if you want to apply this to life, it is extremely easy to create an agency relationship. There doesn't need to be a payment of money. You don't need to hire somebody as an employee. It's really consent plus control. So if the parties are agreeing that there's a relationship where one person's doing something for another person, and the person who is the principal has exerted some control over the agent, then there can be a finding of agency. And in some of the later episodes, we'll get into some other ways that you can create agency, even when there isn't control and there isn't consent. All you accountant listeners, definitely make sure your engagement letters make this clear. Oh, and get them signed, by the way. If you haven't done so, make sure you get your engagement letters signed. There's a lot of convenient cloud-based solutions that they talk about on the Cloud Accounting podcast to make sure that you get, Panda Docs or HelloSign or Adobe Sign. Get those engagement letters signed, for goodness sake. Blake, do you want to participate in the improv, or do you want to watch?
Do I have a choice?
You do.
I've never done improv. I did a little bit of it when I was a kid. I guess they tried to get us to do it in acting class.
There's one rule of improv, which is essentially accept offers, or sometimes they call it yes and, or
Yes, and.
explore and heighten. So accept the reality of whatever someone says and build on it a little bit.
I'm willing to try.
All right, we're going to put you into a scene.
So, ladies and gentlemen of the jury, again, I would just like to point out, I am not going to mention insurance. There will be no mention of insurance and any money coming from insurance. But I would like to point out that when maybe you find her guilty, maybe the money is coming from somewhere else. Just keep that in mind. Keep that in mind, not mentioning insurance. So, this woman, she can handle the debt of whatever is taken on her. Whether we ensure that she has the money or we don't, I'm sure you can find her liable for quite. Okay, sorry. The judge is calling us over. Jury, if you could just wait a second, we're gonna have just a quick little meeting.
Counselor.
Yeah.
If I've told you once, I've told you 100 times. I don't think it's fair for you to be mentioning insurance in front of the jury. There's a long line of cases that says you're not supposed to talk about insurance, and you keep doing it. So I've got to ask you to just tone it down.
Oh, okay. I'm going to point out that I actually specifically said that I'm not mentioning insurance, but I point taken.
Okay, I'm going to have to instruct the jury to avoid a mistrial.
Okay, go for it. Go ahead.
Ladies and gentlemen of the jury, you may have heard the attorney for the plaintiff refer to insurance, and not necessarily whether there is or isn't insurance. But I just want to make clear, you don't pay attention to whether or not the defendant has insurance, because that's not proper for consideration. If we were going to talk about insurance, we would be using the word insurance, and we're of course not using the word insurance because that's not relevant to your consideration as to whether there is any insurance. So please proceed, counselor.
Thank you so much, Judge. So, jury, if you can be assured of anything, if you have any assurances in this world, it is that whatever you find this woman liable for, however much it makes sense, because some people for instance, have little umbrellas if it's raining. And some people have big money-filled umbrellas, ka-ching, ka-ching, and you can put as much water on them as you want. Okay, so remember that when determining damages.
Counsel.
Oh, yep. Oh,
Counsel,
yes.
Ladies and gentlemen of the jury, I need to instruct you that the plaintiff's attorney's reference to an umbrella is a metaphor for insurance. You see, many types of insurance policies are like an umbrella in that they prepare you for a rainy day, a trial being a rainy day. And the money that he's referring to is an insurance company paying. And so I want to make sure you are not to pay any attention to the metaphor of an umbrella, because the metaphor of the umbrella, it's suggesting that there is insurance, which is not something you're allowed to consider. But whether or not there's insurance is totally irrelevant to your consideration. So please disregard the reference to the small or large umbrella.
Thank you so much, Judge. I would also like to, again, apologize to the jury. I know that if the defense seems to have something, I just real quick just want to apologize to the jury for bringing up insurance and for bringing up umbrellas. I apologize for saying ka-ching, ka-ching. Okay, I apologize for at all making you think of the large insurance policy she likely has. I'm so sorry. I'm so sorry.
Yes, Counselor. Again, we're talking about not insurance.
Yes,
we're talking about not insurance, which is where we're not talking about insurance. So, ladies and gentlemen of the jury, please disregard the reference to not insurance.
Step right up. Step right up. Get your assurance insurance. One day you will run out of assurance and you'll need insurance for that assurance. You, sir, you look like you could be assured.
Yes. Yes. My name is Shirley.
Shirley, don't worry. It will surely get better. You don't even need to worry about those terrible shoes you're having. I assure you, one day you will have better shoes.
Wait, I'm sorry.
One day somebody might not tell you this. One day you may need someone else to tell you. And that's why assurance insurance is here for you.
My wife made these shoes. She's a cobbler. I'm sorry. Why are you insulting my shoes to sell me insurance? I like these shoes.
This is assurance that you will need insurance. To be assured. So how can you be needing of assurance unless you get insulted first, right? I mean, come on.
Oh, okay. I'm sorry. I thought this one was insurance. So what I'm doing is I'm giving you money, and then you later on will just come back and assure me that everything's okay.
And that it was a good idea to give me that money. I assure you.
Okay. You know what? Let's sign up.
All right. Yeah, we've got one now. And who's next? Who's next for some insurance?
Hello. I'm very upset because my husband, you see him over there, he just threw my shoes that I made him in the trash. And I'm very upset about it. I worked for weeks and weeks and weeks as I'm a cobbler. Not the type like a pie, but like a person who makes shoes. I made shoes for him for our 3rd anniversary, and he just threw them in the trash and threw money at you. I don't understand. I can assure
you, Matt, that's enough. I can assure you that this is to ensure that the little boy in the street who doesn't have any shoes will one day have shoes from digging through your trash. Your husband sounds like a charitable man, and you sound like you didn't measure his feet right. But I assure you, with this new measuring of assurance insurance, you'll be able to make better shoes.
Oh, thank you so much. Here's a big bag of gold.
I assure you that was a very logistical idea. Thank you. Thank you. And you, sir, I assure you that car that you came out of will ride smoothly for the rest of your life.
Wait, this has gone on from assurances to just vague predictions of the future now.
That's the thing with assurance. It's a combination of validation and guessing.
Oh, I'm sorry. Oh, I'm sorry. My stomach. Oh, I'm sorry. My stomach is acting up. Oh, I think something's happening. Oh, I think I'm having kidney stones or something.
Yeah.
You get
Well,
nothing for me? I gave you all that money, no assurance at all. You should be about. Oh, jeez.
I probably get that checked out.
Darling, I think maybe we should take you to see a doctor. Something.
Now, if you're looking for medical insurance, you'll have to talk to my partner.
Yes, I offer emergency medical insurance. We'll sell you a medical insurance as you're having an actual medical emergency. Our rates are very high, but we cover all the expenses of your hospitalization. Sir, it appears you're having kidney stones.
Yeah, absolutely. So I didn't want to go in because the doctor said it would be at least $500.
That's no problem. We can cover that doctor bill. You'll just need to pay our $10,000 premium.
I would. Why would I? Oh, why would I do that?
Well, with medical insurance, we pay your bills. So all you need to do is pay for your emergency medical insurance, and we'll pay that doctor bill.
Well, it looks like somebody needs insurance. Yes, that's right. Unexplained insurance bills could come up at any time. And who's going to pay those? You? Another insurance person? No, just give me $11,000 and I'll gladly pay my friend over here the $10,000 he needs. That's right, insurance. So you can be assured that you will surely be fine.
Oh, thank you so much. I did need some insurance after I'm on the hook for $500 now that I've sold this $10,000 medical policy. So I'll gladly sell it to you for $11,000.
Sure, you bought insurance, but did you buy insurance to be at the seashore? Shore insurance is surely the way to get your insurance surely better by seeing the seashore when you're insured. Call now to be insured by the seashore. Care of Jersey Shore. Honey, did you see that ad? I know we have life insurance and medical insurance and car insurance. And homeowners insurance and pet insurance and assurance, but I'd really like some seashore insurance.
I think shore insurance is a great idea, darling. And maybe we'll go to the shore for a vacation or something, and we want it to be insured when we go to the shore. Right?
Well, anything could happen there. You could sink into the sand and never come back up.
You could be bitten by a sand crab or a naughty oyster.
You could be attacked by a flock of seagulls if you eat a Taco Bell sandwich.
You could slip into on a slippery rock and stub your toe.
You could look at a fish and forget to breathe and then just drown right there.
You could eat a hot dog and decide to chop off your fingers and sell them.
As hot dogs.
Exactly. Anything could happen.
And then you could eat a finger hot dog, think it was a regular hot dog.
And then you would get a stomach ache. Yes, and choke, and then you would need medical insurance.
Or you could break a tooth trying to bite through a finger bone that you thought was just a hard hot dog.
So many things could happen at the shore. So many things.
Surely we should get that insurance.
Papa?
Oh, yes, Chester. Come on in. We're just talking about insurance.
Papa, I wish that I could go with you to the shore.
Well, absolutely, youngster. You're just going to need to grow 3 or 4 more inches. Here, have another hot dog.
But my leg, Papa.
Oh, your leg will get better. Here, have another hot dog.
Oh, okay. Thank you, Papa. That's delicious.
You know, the best thing for a broken leg is probably swimming on a rocky, sandy, crunchy beach.
Yes, swimming immediately after eating processed meat.
Yes, and being attacked by crabs.
Now, Chester, why don't you go jump in the pool now that you've I'm sure that if you swim with your broken leg, it'll be fine.
Oh, okay. It kind of hurts, Papa, but I'll try.
And Chester.
Oh, yes, Mother?
Wear some floaties in case the cast sinks like a stone. We want your arms to be able to breathe.
So you're looking for a new car, huh? Well, we have some of the safest, best cars of 1937, just right this way. So if you come right over here, we've got our first car. This is called the Spike. Every single edge of this car is spiky. So if you drive into something, boom, you spike it and you keep moving.
Well, that does sound pretty masculine.
Yes,
I'm kind of interested.
Okay, well, the first things watch out, opening the door. It is, it's spiky.
So, as a mother of 4, I definitely want to have a strong masculine influence in their lives because their father just died in a car accident.
Oh my God!
I'm so we're looking for something that will substitute the attitude of their father, who was quite reckless.
Well, this I think will do it. And since you're a mother of 4, this has one of the new safety features available just on this car. It's called the Kid Tub. So on top of the car, you can put all 4 kids in a little tub on top. That way, if you get into an accident, God forbid, the tub will just fly off and turn upside down, keeping your kids safely encased inside.
Now, is there water in the tub?
Only if you want there to be.
It seems like that would, if you're falling on water, it would hurt less than just cement.
Well, that's a good point. And that's why I think you might be more interested in this car right over here. This car is half car, half boat. It's car on the bottom, but boat on top. Now, I will warn you, because it's car on bottom, it takes on water very, very quickly. And because it's boat on top, it's very, very difficult to steer because you steer via rudder, which doesn't gain a lot of traction in the air. But what you get is you get the safety of a boat, right? And the speed of a car.
Oh, Mabel, I just admire your new automobile. This is just delightful. It looks as though it's some like a sailboat on the top, or it's got a mast and sails, and it's just delightful.
Oh, Mavis, I got this because I was hoping it would impress you. Well, let's take it for a spin.
Color me impressed. Now, am I going to be your first mate now that we're going to ride in your car boat?
Yeah, I was thinking we drive straight off the bridge and see how it just hits the water.
Oh, yes. I'm delighted, Mabel. I always, you're so adventurous ever since Jim died. Just always up for a new adventure.
Well, Mavis, if there's one thing I learned from losing a loved one is that now is all we have. So bottoms up. Let's get drunk and hit the road.
Sounds wonderful.
Nothing like Coca-Cola and brandy.
So true. Oh, you're driving very straight. And this bridge is so curvy.
I learned that a straight line is going to build the most momentum if we want to make it across.
Oh, that's fantastic.
To just break through the...
Oh, that's fabulous.
Yeah. Okay, pedal to the metal. Here we go.
Okay. I don't even know what that expression means, but it sounds sexy.
Oh. I learned it. They'll remember me.
Wow!
Will it float? Will it float?
Will it float? Will it float? And that's an episode of Will It Float, the latest radio broadcast show coming to your ears on WYYY. Will It Float, where we cover all kinds of objects and wonder whether they'll float. On Tuesday, we'll be testing out a rock. Will it float?
Probably not.
That's right. You get to hear whether something floats. Now, can you hear it floating? Probably
Is it going to
not.
plop or will it
Well,
plunk? Will
Oh,
it splash or will it fizzle?
we don't know. Oh, I just dropped something now. Did it float? Listen.
I couldn't give two shits. Oh, wait. Maybe one. I heard it.
I'm sorry, producers of Will It Float? Could you come in here? I'm sorry.
Yeah. Mhm. Yeah.
So I sponsored this new show, and I think you're just trying to mulct me. I'm putting all my money into the show. I'm throwing money into pools. I'm throwing money into safes.
Is it floating?
I don't know. I can't tell.
Well, how are you going to know if we don't have our show?
Yeah.
You're not going to know. And the people, they want to know. They want to know. We haven't invented things like repositories for information where you can simply type on a typewriter and know the answer. So we have to find out things by experimentation. Maybe someday in the distant future, people will be able to find out answers to questions by simply typing on the typewriter.
Every time your prediction about typewriters that predict the future and serve up porn and sometimes offer streaming movies, whatever that would be. I don't care about your predictions of the future, okay? It is 1937, and here's what I know. I know I'm being mulked.
Mhm.
I know I'm being mulked. I know I'm being skidamaradooed. I know that every single one of you thinks you've got the big high twirly-do on me, okay? But
Hey,
you
well,
don't.
you know, I just want to say I don't appreciate that language. You know, mulked is that Idahoan slang is something that we're trying to move past in these times today, and I just want you to recognize that it's important to use the right language. And should we have asked you to, you know, I think you should pay for the services we rendered. And honestly, I have some mulch coming to the house, and it's making my sinuses close up quite a lot.
I appreciate you talking about your sinuses, but Mr. Moneypants, I'll assure you that I would never skinnamarink-a-dink your jingle jangle. I will only ever honestly and truthfully represent whether something will float or not float. I would never goofaloob your monkabank. I will only tell you the truth, and the truth is most things don't float.
Fine.
Fine. Excuse me.
Yes.
So sorry to interrupt. I'm the accountant on this production, and all of the sponsors have pulled out ever since you threw that orphan into the ocean with their legs tied.
That was not one of our finer moments.
I don't know what we're going to do. We can't pay the bills.
Didn't we have an insurance policy, orphan insurance?
I don't see that anywhere in the books.
But the problem is once you tie their legs together.
Oh, it's intentional.
Right? It's intentional.
Oh, it's intentional. That's an exclusion on the policy, I believe. Intentional orphan tying. If we had just, well, wait a second. People don't have little television studios they carry around with them in their pocket. Okay, it was an audio broadcast, right? There was no way of looking something up or recording it as though, wait, television hasn't been invented yet. So let me tell you about my idea for television. Oh, I get beside the point. The point is nobody saw us do it. That's my point.
Lest we forget, that orphan was an intentional orphan, as he did dispose of both of his parents.
I say we do something to this insurance policy, and we just tell them that we didn't tie his legs together. That'll cover the bills for quite some time.
Okay, you know what? I'm going to do what I can. Okay, but everybody's pulled out, so I'm on the hook for $23. Okay, do you realize how much that $23? That's the annual budget of this entire radio station.
Well, I think we just need to go hit up Mr. Moneypants again and tell him we won't going to make any more. We'll make another show. We'll tell him we'll make another show. We're going to do his biography. Let's do his biography and see if we can't get him to donate to the program. What do you say?
There is one other option. You could go back to the Spike Car Company. They did want to advertise, but you turned them down. They might be our last resort.
You're listening to Will It Float, sponsored by the Spike Car Company. Are you worried about safety? Then why not step into one of our wonderful new cars? For instance, the sandy car. Each tire is filled with a little bit of sand, not completely, but just half. So as you drive, the sand kind of spurts out, creating a nice soft sandbank for you to crash into should you crash. Sound like too much for you? Well, don't worry. We have even safer cars, including the meat car. What's safer than a cow? You ever seen a cow get into a crash? Probably not. So why not drive around a repurposed cow? You'll be safer than a steer, steering your way right to the ranch. Giddy on up. That's right. At the Spike Car Company, we care about you because you're our most important resource. Now back to Will. Oh, will it float?
Yes, will it float? You know, I'm your host, Dougal McDougalston, and I am here with another orphan. Now, I want to assure you that this orphan is 100% not tied up. Now, let's find out whether an orphan will float. Yes, Timmy. Yes, Timmy. Get over here, Timmy. Okay. Now, Timmy, just tell the ladies and gentlemen at home that you're not tied up. 100% not tied up. Perfect. All right. And away you go. Let's see if Timmy will float. He didn't float.
We at the Spike Car Company would like to apologize for everything that happened in that episode. If only he had been driving one of our special lead cars, a car made entirely from lead and the new super material, uranium. That's right. Drive around a car of lead and uranium so you can be as safe as science. Cops. It was that's the guy I borrowed the gun from. Yeah, when I shot the storekeeper, I borrowed the gun from him. So you can.
Oh, we better go arrest him. I'll go arrest him. Get over here, sir. You loaned a gun to this robber/murderer?
Yeah, what of it?
Well, he said he borrowed it from you, and since he borrowed it from you, you're going to be responsible for a murder/robbery.
No, I just loaned it to him.
And did you tell him what to do with it?
No.
All right,
but he also didn't say don't rob anybody.
Oh,
that's true.
Thank you for your help, Bob. Appreciate that.
No problem.
So you didn't tell him not to murder/rob.
I told him what did I on second thought, maybe I told him to not murder my neighbor.
So you were trying to control him. And did he say he wouldn't murder your neighbor?
He said he wouldn't not murder my neighbor.
Wouldn't not murder your neighbor.
Yeah.
Wouldn't not.
That sounds like a double negative.
It's a triple negative.
Wouldn't not murder. Right. So
but then I said I wouldn't not mind if you didn't not murder my neighbor. I got kind of confused, to be honest. I don't know where we're at. Are we okay?
You are definitely not okay. You're coming with me, sir. You're under arrest for number 1, improper lending of firearms, and number 2, improper use of quadruple negatives.
Do I get to call my lawyer?
Well, this is 1937, son. Do you think that every criminal defendant has some kind of a right to have a lawyer?
Let's just say you can't not
That's
call
right.
your lawyer.
You can't not call your lawyer.
I deserve that.
Only people like Mr. Moneypants, the ambassador to France that is recently settled in our community, can afford a lawyer. And he's the one that committed the murder/robbery for whatever reason. Yeah, I hope you rot in there, by the way.
So I'm just going to go free. See you all guys later. Sorry again about all the robbing and the murdering. Thanks for letting me borrow your gun.
Yeah, no problem. Great to see you. Yeah,
good to see you. Good to see you. Oh, hey, officer. Can I borrow your gun real quick?
Well, absolutely, Mr. Moneypants.
Thank you very much. Oh, seems like the officer got shot by his own gun.
I'm okay.
Nope,
not okay.
Not okay. Okay, I think legally, this seems like a self-inflicted wound.
He's right.
Thank you.
Luckily, it wasn't fatal.
I mean, I just shot you in the elbow, so.
Yeah. But I still got another one. We're cool.
As long as we're cool, then we're fine. Okay.
Cool.
I was worried if the officer would not think I was cool. So, well,
all right. I'm just going to be going over here to get some an operation. I'll be back soon.
Hey, welcome to the hospital. Welcome to come on in. Come on in. Come on in. Looks like you got a problem with your elbow there, huh?
Yeah. Shot myself with my service pistol. Well, I mean, I didn't. I loaned my service pistol to Mr. Money Pants, and he shot me in the elbow, and I kind of considered it an honor, to be very honest. And also, I noticed my voice got deep and gravelly after it happened.
That happens a lot. It's a vocal elbow funny bone connection. It's once the funny bone goes, it kind of snaps the vocal cords like a little thing, and makes you a lot raspier and gravelier. But yeah, come on in.
Okay. So do you think you can operate it on it, or put a cast or a splint or a tourniquet?
I will say this is less a hospital. This is kind of a school of sports medicine. So we have one thing that we can offer you. It's like it's a salty sweet drink.
Whoa, that sounds delicious.
Yeah, we've got some names like crocodile juice.
I would love that.
Or lizard liquid.
Also good.
Okay, we're trying out some things. Snake serum, maybe.
Do you think maybe before I'm happy to drink whatever you want to call it, but do you think maybe we could just, do something about the bleeding?
Okay, well, let's see what we got. I hold on. I'm going to consult with my other doctor. Let's see what we have for this guy's bleeding. We got some racquetballs. This is School of Sports Medicine. I'm doing what I can.
Okay. I'll take the racquetball. That should be fine. I'll just sort of put it in the
put it in the nook
in the wound, kind of where it's where the bullet went through.
Yep.
And I'll just put it in here and should I just hold it?
Just hold it a little bit and do a little bit of walking. Walk back and forth.
I'll walk it off.
Give us a good walk.
I have to say I'm feeling a little bit better. Why don't you hand me that lizard juice, sir?
Sure. Take a swig.
Why, it's quite delicious. It's quite delicious. I feel refreshed and rejuvenated and almost like a new person. Lauren, thank you for being on the show. I know you have to go commute to the thing you need to go to, or drive your very safe automobile that doesn't have spikes on it.
Thank you all. Thank you so much.
Nice to meet you, Lauren.
Nice to meet you guys. See ya.
In our last act of the show, we play a game called Laying Down the Pretense. This is a game show in which I ask you questions. There are no right answers, and I award random amounts of points. Question number 1 is going to Blake. Blake, which dinosaur would make the best politician?
A pterodactyl.
And why?
They just look so majestic.
That's a great answer. You get 100 points, Blake. You're off to an early lead here. Now we're going to go to Curtis. Curtis, if you were put in charge of creating a brand new global holiday, what would it be?
It would be Year Day. And the idea with Year Day is it lasts 365 days, more once every 4 years. And it's just, that's the whole holiday. For 1 full year, you get that holiday. And it's an annual holiday. So basically every year you get Year Day off.
That's a fantastic idea. Full credit. 100 points. All right, Blake, this next one's going to you. Which superpower is the worst one?
Invisibility,
And why is that?
because you're always naked.
That's true. That is kind of a bummer. And then, you have to take,
You're cold or you're
Mhm.
hot all the time.
I think I read The Invisible Man by H.G. Wells, and I found that mildly disturbing that, basically there's this naked guy like hanging out in people's houses. He's like,
Well, and, like-
you can't see me when I'm naked.
What about when you're in crowds and stuff? Like people are
Right.
brushing up against you. Like
So awkward.
it's really.
It's very uncomfortable. It's very uncomfortable. Full credit. That is the correct answer. Most of these don't have right answers. This one, that was the right answer. There isn't another answer. Sorry for those of you that are playing at home and came up with another one like telekinesis. You're wrong. It's invisibility.
Telekinesis is a good one.
Yeah. All right. Curtis, last question. Which color is the most impolite when invited to a bachelor party?
Which color?
Color itself personified
Oh, if the color itself were invited,
is the most impolite specifically at a bachelor party.
I'm going to say purple.
You're right.
Because purple shows up to a bachelor party and thinks, this is about me. This is about me, purple, right? And it's not about you, purple. It's about the bachelor.
Right.
He's about to get married. Let him have a nice time. He wanted to have this nice bachelor party where, I don't know, we all play laser tag and then go see a ball game, okay? Oh, isn't that nice? That's so sweet. What a sweet little bachelor party. Now purple shows up and says, but what about me? What about purple? Why go to laser tag when we could instead go on a yacht? Like it becomes purple's show.
Notoriously, famously narcissistic purple. In fact, I could have asked the question less qualified. I could have just said which color is the most just obnoxious generally at parties, and this would have been the same answer. So correct. Well, both of you got full credit. It's a tie. You both won. Thank you so much for playing. Before we go, though, I'd like to do some shameless self-promotion. What's coming soon from you, and where can people find you on the internet and social media? Let's hear from you, Blake.
I am at Blake T. Oliver on Twitter, and you can check out Earmark CPE to get free CPE for listening to podcasts. I mean, why get CPE any other way? EarmarkCPE.com.
earmarkcpe.com. And if you're already listening on the app, give it a like, a thumbs up, something or other in the App Store so that more people download it, or tell a friend. That's the best way to spread a message. What about you, Curtis?
You can also find me on Twitter at Actually Curtis. And I'm currently working with the Comedy Co-op. We're starting up. We're going to be like a worker-owned comedy theater. So that's the Comedy Co-op LA. You can find us on Instagram and on the internet, which is that magical typewriter that Billy mentioned earlier, and many other places. Hopefully we've got some shows, and hopefully we'll have like a theater and even more shows. It is thecomedycoopla.com.
thecomedycoopla.com. Sounds great. Thank you so much, Curtis. Thank you so much, Blake. And thank you so much, Lauren. You didn't get to shamelessly self-promote. At Sweet Relish Films, at La Orange Mike. And thank you so much for being on the show. That's it.